Alright, this will be the People News. Alright, you know what I always say. Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. Use the Second Amendment. Arm yourself with knowledge. Okay, I'm hearsay. The video's hearsay. Do your own research. Okay, I'm not making any money or anything like this. This right here is not beneficial. For my benefit. Well, it is actually, because it educates me and I can go through my videos, so it is actually beneficial to me. And this is the reason why I make the videos. Alright, I'm not an attorney, so I'm not giving legal advice. Educational purposes only. Okay? So, also realize, y'all, some of these things. Again, we shouldn't have to be going through all these steps. The number one step, here in Texas especially, but the number one step is to be able to get the probable cause before going to jail. So nobody loses their livelihood. So nobody thinks you're criminals at home. All these things, right? And I know I repeat this over and over and over, but we all, 95% of us in the United States, has become a creature of habit. And these judges has been creature of habits ourselves due to us, we the people, as being creatures of habit to get along, to play along, and all these kind of things. You know, this probable cause hearing shouldn't take months, right? The only reason why it takes months is because they're trying to convince you to do a plea deal. So the prosecutors convincingly a judge and turn around and do the exact same thing these other judges are doing. Okay, I am led to believe and do believe that these judges, when you challenge jurisdiction and all this kind of stuff, right, asking not guilty, no contest, guilty, or whatever, you know, if you don't answer them, then the judge is going to just say, well, I'm going to say you're not guilty. Okay? Even though that's a legal determination and he's not authorized to do so, first jurisdiction must be completed. There must be proof that they even have jurisdiction. So the judges automatically should look at the subject matter in said case before anything else, which is what? Probable cause, people. There has to be probable cause to be in front of that judge. This is not complicated. The judge don't even have a right to ask you whether you're guilty or if you're not guilty or guilty, right? He don't even have a right to ask you. That's a violation of your due process rights, right there on the top. Why? Because when you walk in there, you're presumed innocent, people. And these people keep showing up at court to get this probable cause hearing, but they already spent time in jail because they unlawfully put people in jail. And everybody has become a creature of habit of this. And now, when somebody challenges it, oh, it's a sovereign citizen. Oh my goodness. Oh gee Louise. Oh, what shall we do? Fucking nonsense. Like my last video, right? Talking about dress codes. Okay, so I would let him slide because I am led to believe and do believe at the present time he's acting in an administrative capacity and not a judicial capacity. However, everybody's basically saying that he's a judge. So maybe He should show the courts respect and actually have a black robe on. Okay? I don't care personally right off the top. Okay? But, I mean, if you're going to call people out, think outside the box, right? So, and then you got some of these other ladies out here, she may be wearing a skirt, but heaven forbid if a guy actually wears shorts. Okay? Or maybe a kilt. Just sit and think about that. What would this judge actually say if you walked in there in a kilt? All right, enough rambling. The way society is right now, I'm not really technically knocking the guy down. However, if he's actually been educated and he actually understood the law of Texas, he knows everything's backwards. And maybe this is his way of trying to moving up in the ranks and actually create a little bit of more cleanness to the system. But to clean the system, he must be on call 24 hours a day. Oh, but he could get tired. I'm a fucking truck driver. Okay? I'm oil field. Half my life. Alright? We was on call 24 hours a day, 7 days a week. Give me a freaking break. Alright. Sorry.
Ogarro. Ogarro. For sure. Good morning, Mr. Ogarro. Sir, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews in the state of Texas. If you cannot afford a lawyer, a lawyer will be appointed to represent you, sir.
Counsel. That part right there irks me, as you can tell. That being said, constitutionally speaking, nobody actually has to read you your Miranda warnings. Just to let you know. Okay? But since they're putting it on there, take full advantage. Keep your mouth shut.
On June 29th, 2024, officers were dispatched to an assault in progress in Harris County, Texas. Officers observed a black SUV which had 3 people inside and confirmed it to be the vehicle of interest. The defendant got out of the driver's side of the vehicle and began to walk away from the officers. The officer then told everyone to stop, and the defendant kept walking away, ignoring commands. The officer told the defendant multiple times to stop, but the defendant did not comply and began evading on foot from the officer towards an apartment complex. Foot pursuit began, and another officer then drove towards the defendant and gave verbal commands to stop, announcing Houston police stop. The defendant was eventually caught, and officers were able to place the defendant in handcuffs. The total approximate length was 1/4 mile. Upon return to the original scene, all other parties had left the scene along with a vehicle of interest.
What was the detention for? What was he doing wrong?
Officers were there on an assault call and had a description of the vehicle. And once they saw it, they approached, and that's whenever defendant.
Do you have more than just an assault call? Any kind of identifying factors? I mean, it's really just vague how there's just cars don't assault, you know?
See, this is actually what he's thinking. Now, previous, I understand that he don't understand the way it's supposed to work, but he really does actually pay attention to the probable cause situation when it is before him. So, and this is where I have respect for him, okay? Anybody goes to jail before this, and he's ignoring, I don't like. But that being said, as a creature of habit today, it is what it is. But just listen to what he's saying, right? And again, the officer is going by information. Where's the affidavit? Okay? Just saying. And it may take too much time and but to go and arrest people by the information and never show by these people here the affidavit. It's missing from the victim. It's always from a liar officer. Okay? I'm not saying all of them lie. I'm just saying they're legal to lie, so it gives me pause. Right? Should I trust the information? Should I even trust their affidavit under penalty of perjury? Because, well, the qualified immunity gives them a way out. You go to jail if you commit perjury, but the officers don't, judges don't, prosecutors don't. They got all these kind of protections.
Like if there was some kind of description, someone in the car had assaulted someone or something to that nature, but just.
I mean, officers were able to confirm the vehicle by the license plate given from the call.
Okay.
So they confirmed that it was the defendant's vehicle that they approached on.
And that may be true or not. But hearsay is still hearsay. I can get tags off of anybody, and I can retaliate against anybody I want, or just start crap, right? That's what CPS is for, allegedly. It's just for people to start crap.
Do they say that someone assaulted someone, that there were.
Just that it was just an assault call, Your Honor.
Yeah, I need more than that. I mean, it's really vague. It's presumptuous. It's. No, Beetle, do you have anything else?
I'll look at it. Just let me take a look at it.
Okay.
If you just
Just do me a solid, will you? Just take a seat for me. I want to make sure that there's probable cause if there is. If not, I'm going to cut you loose. But I want to make sure that there really is. So just give me a second and then we'll get back with you.
Later that day.
Judge, I see what you're saying about my case. If you want to do whatever you want to do,
That's it?
then I'll resolve it. I mean, I think you were questioning whether it was probable cause.
Right.
Related to the case.
There's nothing in it.
I don't really disagree with you.
Okay. Come up, sir.
Right there, they started. People. Aren't these supposed to be the attorneys? Can't they read their own writing about probable cause? Can't they figure this out before we even get to him? Okay? I mean, I didn't spend thousands of dollars. These people did. And they keep proceeding forward and they keep shutting them down. That being said, here in Texas, I am led to believe and do believe due to my past experience, 98% of the judges would actually say it would be probable cause because they would never do what he's doing. And these people right here should know him by now. There's just certain things he's not going to accept. And why are they wasting everybody's time?
So this was Ogaro. Or Ogaro. Okay, Mr. Ogaro. I'm going to find that there's no probable cause in your case. Just be careful out there, man. People are always out to hunt you down, you know what I mean? Just be careful, don't put yourself in the spot, okay? All right, you're free to go.
And there's people hunting you down. Is that not true? and officers out there hunting you down. Just them little words. He's letting everybody know at the very end, be careful out there, that you can't trust them. As you've seen today, sir, Mr. Gonzalez, or Mr. Diesel, or whatever, as you've seen today, you can't trust nobody over here. You can't trust officers over here. They're all out to get you. Diesel, We the People News. Till next time. Bye, y'all.